Welcome to INAN's Advocate. INAN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have Advocate Mohib Khan. Advocate Mohib Khan has graduated law with CWC Law College in the year 2022. He practices in criminal laws in various criminal courts in Mumbai. Today he is going to speak on private complaint under section 223 read with section 210 of the Bharatiya Nagarik Suraksha Sanhita 2023. So without wasting further time, I would request Advocate Mohib to commence with his lecture. Thank you.
Salam to all members of the judiciary, the learned advocates and my esteemed guests. It is an honor to stand before you and speak on an important topic, that is criminal complaint under Bharatiya Nagarik Suraksha Sanhita for brevity BNSS 2023. This topic is crucial to represent one of the fundamental rights of every person, the right to seek justice directly from the courts when the law enforcement fails its duty, and it happens on a regular basis, though we are an advocate or a person in power or a common person. The BNSS 23 has replaced CRPC and continues to recognize the importance of private complaint in ensuring access to the justice, as it has been incorporated in the Article 21 of our Constitution. It is one of the fundamental rights. When an individual becomes a victim of an offense but faces resistance from the law enforcement, from our police authorities in registering FIR or conducting proper investigation so that the person who is aggrieved should get the due justice, the BNS provides then the BNS provides alternate remedy, the right to file a private complaint before a judicial magistrate. Today I will discuss the legal provisions, the judicial process involved, and the significance of the private complaints in our legal system, along with some practical challenges and landmark judicial precedents that would guide us in this regard. First, let us understand what is private complaint under BNSS of 2023. To begin with, let us understand the concept that the purpose of a private complaint is a legal mechanism that allows an individual to directly approach a judicial magistrate when the police has refused to take cognizance of an offence, despite the complainant disclosing that it was a cognizable offence. But under the provision of section 223 of BNSS, not only cognizable offences, even non-cognizable offences can also be filed before a judicial magistrate. When the police specifically refuses to register an FIR but conduct a biased and incomplete and unfair investigation, example, an FIR has been registered but the other accused which should be inducted are not being added while filing of the charge sheet, on this grounds also we could file a private complaint under the relevant sections. Certain accused persons which are deliberately left out in the charge sheet could also be added. The nature of the offence is such that the law does not mandate an FIR, that is non-cognizable offences. The process of filing private complaint is governed under specific provisions under the BNSS 2023, particularly section 223 of BNSS corresponding to section 200 of CRPC. Definition: that allows an aggrieved person to file a private complaint before a magistrate if the police fail to take action. The magistrate must examine the complainant and any witnesses under oath. Second, section 210 of BNSS corresponding section 202 of CRPC. This proviso specifically gives magistrate the power to conduct an inquiry, call for documents and even order an investigation before proceeding further. Similarly, section 173(4) of BNSS, like I have told earlier, if the police file a charge sheet but exclude certain accused person, the complainant may file a private complaint to specifically ensure their inclusion. Section 224 of BNSS corresponding to section 204 of CRPC empowers the magistrate to summon or warrants against the accused if prima facie a case is made out. Now let's talk about the procedure for filing a private complaint. Let's talk step by step involvement in filing a private complaint before a magistrate. Initially, you have to draft and filing of a complaint. You have to ensure that the name and address of the complainant or the victim who is seeking the justice needs to be there. The details of the accused persons, to your limited knowledge, should also be incorporated. The specific offence committed and the specific sections under which the accused should be prosecuted. A detailed narration of facts including date, time and the place of incidents, which has to be true to your limited knowledge, or else it will carry another offence against you if you lie before the court before in oath and in the form of affidavit. Any documentary or material evidence supporting the complainant, and if in case if there is any, the name and statements of the witnesses. Second, once you file this complaint, it will be kept for examination of the complainant and the witnesses under section 223 of BNSS. After filing, the magistrate examines the complainant under oath to ascertain whether the allegations disclosed is prima facie a offence or not. If unfortunately the complaint lacks any substance, or the magistrate's prima facie or ex facie finds out that the complainant that no prima facie offence is made out, then he may directly dismiss at this stage only. The moment you tender your examination, your verification, then the counsel will argue, and then the magistrate will come to the, and if the magistrate comes to the conclusion, then directly it may dismiss it. If the magistrate finds some substance, but he does not, but the learned magistrate doesn't want to straight away issue process or invite the accused directly to the trial, the magistrate may order an inquiry, a preliminary inquiry under section 210 of BNSS. Once the magistrate takes the cognizance of the offence, prima facie, and if required, the magistrate may conduct a preliminary inquiry or direct the police to investigate and submit a report within the given period of time. This provision ensures that false and frivolous complaints do not proceed to trial unnecessarily and does not burden our already overburdened courts. Step 4. Once the process is issued, if the magistrate is satisfied that there is sufficient grounds for proceedings, he or she will issue the summons or the warrant against the accused, initiating the trial process. Now, what is the importance of private complaint in criminal justice? Why the provisions of private complaints are so crucial in our judicial system? It is a remedy against police inaction. In many cases, the witnesses face hurdles in getting their complaints registered due to n number of political pressure, corruption and police indifference. Private complaints allow victims to bypass police inaction and directly seek justice from our courts, as this seeking justice is one of the God-given rights to each and every person living across the globe, not only for this our great country, but across the globe. It is a protection against unfair investigation. Now, supposedly, even if a FIR is registered and sometimes the investigation is conducted in a biased manner, leaving out the key accused as or failing to collect important and crucial material for evidence, a private complaint ensures that the judiciary has the power to intervene and correct such injustices. It is important for upholding the rule of law. If private complaints were not allowed, law enforcement agencies would have unchecked power to decide whether cases should be investigated or prosecuted. Now, by allowing individuals, common people to approach magistrates directly, the BNSS enforces judicial independence and accountability. There are several landmark judgments which have interpreted the law on private complaints and provided a guiding principle. One of such cases is Priyanka Srivastava, Supra, the Honorable Apex Court ruled that private complaints should be supported by an affidavit to prevent frivolous litigation. It also emphasizes that the courts must ensure due diligence before issuing summons. Another landmark judgment is of Ramesh Kumari Supra. The court held that the citizen has a right to approach the magistrate when the police refuses to register an FIR. Sushil Kumar versus the state of Haryana, 2023. The Apex Court ruled that the magistrate has the power to further investigate even if the charge sheet is filed for the sole purpose to ensure justice. It comes with certain challenges and safeguards. While the provisions of the private complaint is an important tool, but as for each and every proviso, for each and every act, there are challenges associated with it. The leading examples in our day-to-day life are 498A and, with no offense, the women-centric laws, which are misused on a daily basis, and we witness them on a daily basis. Similarly, frivolous and malicious complaints. Some individuals may misuse private complaints to harass others, just to have an iron grip on them. The courts must exercise caution and impose cost when they find out beyond reasonable doubt that the individual has filed a false complaint. A high number of private complaints can lead to judicial delays. Proper scrutiny at preliminary stage is necessary. Then the magistrates must balance the rights of the complainant with the rights of the accused, ensuring that no one is wrongly prosecuted. That is the very reason, under the new proviso of section 223 of BNSS, para number 2, it states that provided that no cognizance of an offence shall be taken by any magistrate without giving accused an opportunity to be heard. That means the moment a complainant files a complaint, his verification is done. The complaint along with the verification needs to be sent to the accused in order to ascertain what is their say and call for their say. And then prima facie, after the arguments of the counsel, the magistrate will decide whether to dismiss, whether to issue inquiry, or whether to issue summons against the accused. Now, another problem with this, as discussed with our juniors like me in various discussions in bar rooms, supposedly if an individual gets robbed, he doesn't know the whereabouts of the accused, the police is not ready to take FIR, they are not ready to take cognizance. So even if he files a complaint, he files a private complaint, so who to serve? But this question seems to be answered by the Apex Court, and it has to be interpreted. There is a bit of a grey space, as we can call over here. But anyhow, now going towards the conclusion. To conclude, the private complaint mechanism under BNSS 2023, it is a vital safeguard against police inaction, ensuring that every citizen has a right to seek justice, the spirit of judicial activism, enforcing the rule of law, and access to justice. However, the responsibility with legal professionals and the judiciary is to ensure that the provision is not misused. We must advocate for a balanced approach, protecting victims while preventing the misuse of law. With these thoughts, I would thank you all for your time and attention, and let us continue our commitment to upholding justice and the integrity of the legal system. Jai Hind, Jai Maharashtra, Khuda Paman.
Mohib, thank you very much. It was nice hearing in a very crisp manner a topic which is a private complaint, and this is one of the very hotly discussed topic when this BNSS has come into effect. So we are really happy that we have touched this topic, and it was a nice overview of this particular concept. So thank you, and a small token from Hammurabi to you.
Thank you, sir.